We'll like to apologize from the foundation to having made to wait, but certain things are beyond our control, I guess. May I request the audience to please rise when Chief Guest is arriving. He's right at the door. Honorable Chief Justice of India, Justice Surya Kant, distinguished guests, respected faculty members, and dear students, a very good afternoon to you. May I request you all to take your seat, please? On behalf of the Karambhumi Foundation, it's my privilege and honor to extend a warm welcome to each one of you to this distinguished gathering. Karambhumi Foundation Uttarakhand was established in Dehradun in February 2023. It's a non-profit trust dedicated to the ideals of Pandit Dehradun Dhulia, the renowned freedom fighter of Uttarakhand and the founding editor of Karambhumi Saptahik, which was launched in 1939 in Lansdowne. It played a formidable role during the freedom struggle and thereafter. The activities of the foundation are aimed at the welfare and development of Uttarakhand. Our co-host today is the University of Petroleum and Energy Studies, UPES Dehradun, a university that stands at the forefront of academic excellence, innovation, and industry-aligned education. With its commitment to nurturing future leaders across disciplines such as law, engineering, business, and design, UPS continues to shape minds that contribute meaningfully to society and the nation. We are equally privileged to be hosting the event at the iconic Forest Research Institute, a landmark of heritage and knowledge. Known for its majestic colonial architecture and rich legacy in environmental and forestry research, FRI symbolizes India's long-standing commitment to sustainability, conservation, and scientific inquiry. The grandeur of the venue adds immense significance to today's occasion. I'm sure we'll all agree with that. To take the event forward, may I request Honorable Justice Sudhanshu Dhulia to welcome our chief guest by presenting a bouquet. Sir, please. May I request Justice Dhulia, please be there. May I request you to please welcome Honorable Justice Satish Sharma, Judge, Supreme Court. May I request Dr. Sunil Rai, Vice Chancellor, UPES, to welcome the Chief Guest, the Chief Justice of India, Justice Surya Kant. Thank you, sir. I'll request Mrs. Mishra, Director, FRI, to welcome the Honorable Chief Guest. Justice Kulbe, ex-judge, Uttarakhand High Court. Sir, may I request you to welcome our chief guest. And lastly, Shri Vijay Dhasmana, President, Swami Ram Himalayan University, to welcome the Chief Justice of India. I request you all to please walk up to light the lamp. I request Honorable Chief Justice of India, Justice Surya Kant, Honorable Justice Satish Sharma, Honorable Justice Hon'ble Dhulia, Vice Chancellor, UPES, and Mrs. Richa Mishra, Director, FRI. Ma'am, please.
देना हो या खोली का गणेश देना हो या मोरी का नारायण देना हो या गाँव को भूमिया देना हो या पंचनामा देवा जो जस देना आदि बदरीनाथ जो जस देना ऊ बूढ़ो केदार जो जस देना ऊंचो कैलाश जो जस देना पंच परियाग जो जस देना माता सरस्वती जो जस देना लक्ष्मी पार्वती जो जस देना धौली भागीरथी जो जस देना हरि का हरिद्वार जो जस देना नौखंडी नरसिंह जो जस देना सेमा का नागराजा जो जस दीना कुल देव भैरवनाथ जो जस दीना पीतर देवता.
Thank you so much, ma'am. That was Dr. Madhuri Bartwal, Padma Shri. Ma'am, we are blessed by your presence. Thank you, sir. Thank you, ma'am. I would now like to invite our guests to take their place at the dais, please. Honorable Chief Justice of India, Justice Surya Kant, sir. Honorable Justice Hon'ble Dhulia. Mrs. Sumitra Dhulia, Chairperson, Karambhumi Foundation. Honorable Justice Satish Sharma, sir. Judge, Supreme Court, and Dr. Sunil Rai, Vice Chancellor, UPES. I'll now request Mrs. Sumitra Dhulia, Chairperson of Karambhumi Foundation, to present her inaugural address.
अस्ति उत्तरस्यां दिशि देवताद हिमालयो नाम नगाधिराज पूर्वापरौ तोय निधि वगाह्य स्थित पृथिव्या इव मानदंड. कालिदास के इस श्लोक के साथ ही मैं आज के मुख्य अतिथि का स्वागत करती हूँ, जिन्होंने अपने व्यस्त समय से अपने ही समान कार्य करने वाले व्यक्तित्व के लिए समय निकाला और वो यहाँ पर आए. ये हिमालय की ये भूमि, हिमालय की ये उच्च श्रृंखलाओं का प्रदेश गढ़वाल अपने उन ऊंचे मूल्यों के लिए विख्यात है. यहाँ अनेक अभाव होते हुए भी यहाँ के विद्यार्थिनियों ने यहाँ की समाज के उन व्यक्तियों ने अपनी दृढ़ता, आत्मविश्वास और अपनी सहज कार्यशैली से उत्तराखंड को एक दिशा दी है. उस उत्तराखंड के बारे में कालिदास ने कहा था कि जो उत्तर दिशा में बैठा, आज द्रोण नगरी में न्याय के सिंहासन पर विराजमान उच्चस्थ व्यक्तित्व को अपने बीच पाकर हम एक उल्लास का अनुभव कर रहे हैं. ये निश्चय ही श्रद्धांजलि है उस व्यक्तित्व के लिए जो कि उनके समान धर्मा थे, जो कि उनके समान ही न्यायिक कार्यों में रत थे. श्रीमन, यह प्रदेश बहुत अधिक कई प्रकार के कार्यों से गुजरा है, लेकिन यहाँ के व्यक्तियों में, यहाँ के नागरिकों में जो देश के प्रति सम्मान, जो देश के प्रति आत्माहुति देने वाले असंख्य सैनिकों के का गृह है, ये गढ़वाल जो हिमालय की तरह ऊंचा है और हिमालय की तरह महान आदर्शों की ओर प्रेरित है। मैं अधिक न कहकर अपने इस सभागार में उपस्थित सभी सदस्यों की ओर से आपका स्वागत है, अभिनंदन है। आपने अपने ही कार्य में लगे हुए जिस व्यक्तित्व के लिए समय निकाला, हम उसके लिए अभिभूत हैं और आपका देहरादून की जनता के प्रतिनिधित्व के रूप में उपस्थित यहाँ पर सबके लोगों के प्रति आपका स्वागत करते हैं, अभिनंदन करते हैं और आपके लिए जीवन की मंगल कामनाएं करते हैं। धन्यवाद।
Thank you so much, ma'am. Now I call upon Dr. Sunil Rai, Vice Chancellor, UPES, to deliver the welcome address, please.
Vande Mataram. It's an honor and privilege to be the partner to Karma Bhumi in bringing together this Hon'ble Justice Keshav Chandra Dhulia ji's memorial address, the second edition of this, in this historic place, FRI. At the outset, I welcome the Chairperson of the Karma Bhumi Foundation, Mataji, with Pranam. I welcome the Honorable Chief Justice of India, Hon'ble Justice Surya Kant ji, the Honorable Judge Sharma sir, the Honorable Judge of the Supreme Court, Honorable Judge Sudhanshu Dhulia ji, the proud son of Keshav Dhulia ji, all the two other bright sons of Keshav ji. One, of course, had been my colleague in the Indian Navy, the Himanshu. Both of us served together in the Western Naval Command. Timanshu ji, who actually told us about the Keshav ji. All the famed dignitaries present in the room, all the members of the legal fraternity, my colleagues from the education fraternity, my dear students of School of Legal Studies, UPES, ladies and gentlemen. It's indeed a privilege and honor to be partnering the Karma Bhumi Foundation. We are honored because of three reasons. One, it comes from Karma Bhumi, which was established by the well-known freedom fighter, the son of soil of Uttarakhand, whose son later on went to be the judge at the Allahabad High Court. That journey which the family has travelled from the Lansdowne in Uttarakhand to Allahabad, where they got fully established. And Sudhanshu ji continued the part of that journey when he went as the judge at the High Court at Guwahati, and then, of course, judge at the Supreme Court. Himanshu had, of course, joined the Indian Navy, and we used to serve together. And Timanshu ji, of course, has been introduced already to you as a well-known actor and director. But I just would like to mention here that I think this whole aspect of nationalism, secularism, which Timanshu ji mentioned, the values of human dignity, had been running in the family and in all the three sons. One more thing additional, of course, which Timanshu ji today represents is the art and culture. And let me also tell you, share with you that Himanshu was no less. It is just Himanshu ji has now made it big in the world of films. But Himanshu, wherever you are, we used to be doing a lot of Kalyan Sanskritic programs together for the Western Naval Command. So he is also no less artist in his own right. So the other reason is that the values for which the Karm Bhumi and Keshav ji, Honorable Judge, and Sudhanshu ji stood for is something we try to imbibe in our School of Legal Studies. From time to time, we are blessed by partnership of such stalwarts for whom human dignity and the value system is at fore, which Himanshu ji explained about the way Keshav ji was in his time. Sudhanshu ji also has displayed that. I think his landmark judgment on hijab is something which we all remember, is something which upholds the values of constitution and human dignity. And the third reason that we are very happy to join is that they are sponsoring us to do some great activity at the School of Legal Studies. There are two programs which are sponsored, directed and blessed by Karm Bhumi Foundation, which is a debate competition and an essay competition. Pleases me to report to Chief Justice Sir as well as to the audience here that the winner, two winners, proud winners of the essay competition, one of them, Virendra Pratap Singh, has now earned the seat at Oxford. And the other winner, Soumya, has been now selected to be the LAMP member. She will be now shadowing one of the member of parliament. Now, these two students have done us proud. I'm very proud of Virendra and Soumya. And it is this that is blessed by Karm Bhumi Foundation. Thank you very much, Madam, for guiding us, blessing us, and we honor this relationship. We are honored indeed, all of us today, that we are amongst the Honorable Chief Justice of India, Honorable Justice Surya Kant sir. From very humble beginnings from Haryana, sir's journey has been a testimony to the efforts, to the value system of human life. Sir had been the judge at the High Court of Himachal Pradesh before taking over and blessing us all, first as the judge at the Supreme Court and now as the Chief Justice of India. Sir, you have always upheld the values of transparency in the judicial system as well as for ensuring that justice is available to all. These values we have upheld. We have of course read about you in your all avatars in the legal systems. We are honored, as well as the students sitting here who are going to take this legal profession are certainly motivated to follow your footsteps and of course start contributing to the field of law. Honorable Judge Sharma sir, we are delighted and honored indeed with your presence here, and of course I will expect that someday you bless us at our campus at UPES, and we will look forward to it. In my final essay of things, I would just share with you about the School of Law or the School of Legal Studies as we call it at UPES. UPES, as Madam mentioned, is one of the top universities in India. We are ranked 42nd in NIRF. We are in the first 500 in QS world. We are in first 200 in QS Asia. And all our schools are doing well. The Law, School of Business, School of Engineering also are in the top 50 in the country. The School of Legal Studies is even better. They are the 18th now in the country as far as NIRF rankings are concerned. This all happens mainly because of three reasons, as I understand as the Vice Chancellor, and also at the moment I am also the officiating Dean of the School of Legal Studies. The first one is the value system that we inculcate in our students. Our partnership with Karm Bhumi is proof of that fact. we run what is called School of Life or School for Life at UPES. Our legal studies students take part in grassroots activities in the acquired villages where they go and give their contribution. Every Sunday we run the legal aid cells where we try to guide the villagers and fellow citizens as to how we can resolve disputes without having to resort to further legal proceedings. And of course, we also take part in upper activities. We are the part of SETU, which is the Planning Commission equivalent of the state of Uttarakhand, where the faculty and the students are collectively working, sir, in environmental laws and trying to work towards such SOPs and procedures that will make the life better in the state of Uttarakhand. So our remaining connected with the society is the first reason that the School of Legal Studies is doing well. The second reason is our project-based learning or practice-based learning, which the School of Legal Studies follows. Every week we have at least 2 luminaries from the legal field who come and spend time with the students a full day. And then of course there are the formal interactions and informal interactions. We are blessed that every month we have the visit of some senior judge from the judicial system coming and guiding our students. Corporate lawyers, corporate firms also come up and bless the students. It's a common place at School of Legal Studies that students interact with the practitioners, and that gives us the second edge. And the final thing before I close, which I want to share about our School of Legal Studies, is that we remain at the forefront of technology. We were the first to adopt learning of technology for legal studies by creating an AR/VR lab, which we created in 2022. In the AR/VR lab, we can simulate several cases, several judgments that are being issued from time to time, and students get a real-life feel of how the whole procedure of judgment is meted out to the citizens. We have advanced further, and it pleases me to report to all of you that we have partnered with OpenAI, the first university in India to sign up for 1,000 professional licenses with none other than Sam Altman himself, who has signed the ChatGPT firm, who has signed with us. Lot of AI we use in designing the program, in delivering the program, and also in evaluations. We are also using AI, we also have impregnated almost 10 to 15% of credits in AI in the legal system. That gives us edge, and now that electronic evidences, the electronic hearings that the courts are now permitting, I think we are preparing our students for that future of the legal system in our own humble way. I will with this like to once again thank the Karm Bhumi. I'll pay my respect once again to the Chief Justice of India for gracing this particular occasion for the memorial lecture. I invite you all to please do visit us at UPES, and we will always be delighted and honored to receive you there. Thank you and Jai Hind.
Thank you so much, sir. Though our Chief Justice, Justice Surya Kant, needs no introduction, but I'll still request Hon'ble Justice Dhulia to please introduce our chief guest and tell us something which we all do not know about.
Welcome, Honorable Justice Surya Kant, who's the 53rd Chief Justice of India. My dear friend in the Supreme Court, Justice Satish Chand Sharma, so kind of him to be here. He had to cut short his talk and all from. There's an event going on in Taj Hotel right now of NALSA, National Legal Service Authority. And so both the Honorable Chief Justice and Justice Sharma got delayed because of the program there. Shri Sunil Rai, the Vice Chancellor of Petroleum and Energy University, Shrimati Richa Mishra, Director FRI, my respected mother who's in the dais, many former judges of Uttarakhand. I can see Justice Khulbe, many of my former colleagues of Uttarakhand High Court, senior advocates. I can see Mr. D.K. Sharma, Mr. B.P. Nautiyal, Mr. Pal, Mr. Kohli, Patni, Mr. Bahuguna, so many of you. Sorry, Mr. Kawaljit and Mr. On his right, I always forget his name. Yeah. Thank you so much for taking time and coming here. Members of the media and journalist family who have come in large number. Rahul is here. His father, Mr. Kothiyar, is my colleague, was my former colleague at the High Court. Members of the faculty of both Forest Academy, the Petroleum University and the other Graphic University, Era University. Welcome all of you. And last but not the least, my fellow students. As you know, Hon'ble Justice Surya Kant is the 53rd Chief Justice of India. Actually, I had come something written, but I'll cut it short because there's a paucity of time. And then my friend Justice Satish Chandra will take over and finish what I wanted to say. But this much I must say that, Justice Surya Kant is actually a role model for many of us. He comes from a small village in Hisar in Haryana. His father was a Sanskrit teacher. The family was also doing farming. But that time was born in 1962 and he had an ambition to become a lawyer. And by sheer dint of his hard work, persistence, he persistently plodded his way towards the goal. As most of the law students must be knowing, Justice Cardozo has famously said, plodding can take you quite a distance. There is a joy in that success, and a distinction can come from courage, fidelity, and industry. Justice Surya Kant is all that. And remember, he is the first member of his family who had taken up law as a profession. There was no other member of his family prior to him in the law. But then this was not all. He started his practice initially in the district courts and then went on to the practice before the High Court at Chandigarh. He was the youngest, and perhaps that record has not been broken. He became the youngest lawyer to have become an Advocate General of a state in Haryana when he was 38 years of age. And he continued to remain in that office for 3.5 years till he was elevated again at a very young age of 42 years. And after spending 14 years as a judge of Punjab and Haryana High Court, he was later elevated as a Chief Justice of Himachal Pradesh High Court, and then in 2019 he became a Judge of the Supreme Court of India. I know I had the good fortune of knowing Justice Surya Kant not only when we were colleagues in the Supreme Court, but I knew him much before that. We met so many times in different seminars, conferences relating to law of judges and lawyers, and particularly at the Bhopal Academy. And I could see a sharp mind, an erudite judge who would patiently listen to the problem and in the end come out with a solution which was most of the time acceptable to all. So I have seen that side of it. He has written a body of great judgments, remarkable judgment. I will not take up, I had a list of all that, but I am not taking out all those. But I must mention 2 or 3. One is the judgment of a constitution bench of which he was a part, which upheld the validity of Article 370 of the Constitution, repealment of Article 370. And then second was, which the Constitution bench, a judgment which Justice Surya Kant had authored, which upheld the validity of Section 6 capital A of Citizenship Act. And if you had quoted the passages out of passages from that judgment to tell you about the fraternity, what he wanted to say. And there are beautiful passages on fraternity in this judgment, which I beseech the law students to go through all those. I'm not mentioning the entire judgment, but I cannot stop but mention the recent, it's not a judgment, but the recent order which has come from the Supreme Court of India, from a bench which was headed by Justice Surya Kant, where he, for the first time, he made 30% reservation for women in bar councils of India, in all state bar councils. Because prior to it, because women were not, it's a as we all know, lawyer, and it's a male-dominated profession. And women take a long time to make a place for themselves. This is a path-breaking, a landmark decision, which now reserves 30% of seats in each state bar council for women. That is happening, and many of the elected members of the Uttarakhand Bar Council are here, and they are actually wondering how the co-option will happen, again of women candidates. I must record here my interaction with Justice Surya Kant, because it was not just as a judge that I interacted with him, but there were many occasions in my career, as a judge, in my work as a judge, where I got invaluable advice from him. And he stood like a rock with me at times when I needed it. And those were the times when, because of his advice and because of his guidance, I could come out of those problems and puzzles. So thank you, sir. At this stage, I would only end by saying that at the heart of judicial philosophy of Justice Surya Kant is actually humanity, is actually human being. This is a chain of thought. You can see right from initially when he was a judge of Punjab and Haryana High Court, till as a judge and now a Chief Justice of Supreme Court. I must mention here, it has come to my mind, when he was a judge of Punjab and Haryana High Court, he protected the conjugal rights of inmates who were suffering life imprisonment and even death penalty. That's a remarkable judgment, and he based those rights on the right given under Article 21 of the Constitution of India. So there are many things which I wanted to say, but I am not saying, and I request my old friend, Justice Satish Chandra Sharma, to please come here and please bring to public the hidden aspects in the personality of Justice Surya Kant.
Honorable Shri Justice Surya Kant ji, Chief Justice of India, Mrs. Sumitra Dhulia ji, Justice Dhulia, Bhabi ji, and other family members, Dr. Sunil Rai, Vice Chancellor of the University, faculty members of the University, Richa Mishra ji, Director, Forest Research Institute, Honorable Judges, dear students, Namaskaram. It's really a great privilege to be part of this August gathering. First of all, I would like to pay respect to Mataji, who was the force behind this family. She gave sanskar to all her children, and I was told by Justice Dhulia about the difficult times in which she brought up all the children. So, a big pranam to you. In fact, it was a big surprise for me to come to this place. Day before yesterday, Justice Dhulia gave me a call that we are hosting a lunch in some hotel, Anantara, I don't remember the name. So I am a very frequent visitor to Uttarakhand. It's a Dev Bhumi. Normally, almost every month I am in Rishikesh. But I never heard of this hotel. So I said, all right, I'll come for the lunch. And after the program, I thought we are proceeding for the lunch. So when the driver was coming inside this big building, I said, this hotel has got huge lawns. So the driver started staring at me. He said, sir, it's not a hotel. It's a Forest Research Institute. So I thought a part of this building must be a hotel. So when I entered inside, I saw all this, then I realized I have come for a lecture. But it was a great privilege to be part of this gathering. And I am personally grateful to the Honorable Chief Justice, who has taken so many steps for reforming the Indian judiciary. Earlier still we do have a backlog, but earlier there was a lot of problem in listing of cases in the Supreme Court. But he has streamlined the system. Old cases are being decided, and all judges are working very hard. They are ensuring that pendency is reduced. He has done other reforms also. He has constituted constitutional benches of 9 judges to resolve all pending matters which, with due respect to everyone, which others have not touched them. One of the oldest matter about definition of the industry has been heard, and a verdict is likely to come soon. I really don't know how he works so hard. For us, going to one place is so difficult, and we get exhausted after visiting one town. But he has the capability and capacity to visit the entire country, and he's rightly doing so because the entire nation, the entire judiciary is looking towards him for other reforms which are yet to come. I'm grateful to you, Lordship. For Justice Dhulia said that for paucity of time, he will not speak much, but I will also not speak much for the reasons best known to you. So I'm once again, good wishes to all young students of the university. You are fortunate that you have come here to listen to the Honorable Chief. So I'll not take much time. Thank you and Jai Hind.
Thank you so much, sir. This is a true story when loss is gain. Your loss has been our gain, sir. But we'll promise you lunch. Now I request Honorable Chief Justice of India, Justice Surya Kant, to please deliver his second Keshav Chandra Dhulia Memorial Lecture. Sir, we are eager to hear your perspective on legal awareness and access to justice.
Most respected Srimati Sumitra Dhulia, wife of late Justice Keshav Dhulia, my esteemed colleague from the Supreme Court, Justice Keshav Chandra Sharma, my former colleague and my very dear brother Justice Sudhanshu Dhulia, former Judge Supreme Court of India, distinguished sitting and former judges of Uttarakhand High Court, Professor Sunil Rai, Vice Chancellor, UPES, Madam Richa Mishra ji, Director, Forest Research Institute, very eminent, distinguished personalities of Garhwal and Dehradun region, who all of you are here to grace this event, Shri Himanshu Dhulia and Shri Tigmanshu Dhulia, both sons of late Justice Keshav Dhulia, other family members of late Shri Justice Keshav Dhulia, members of the legal fraternity, distinguished guests, eminent professors, academicians and jurists, and most important for me, my dear law students. It is both a privilege and a deeply humbling experience to deliver the second Justice Keshav Chandra Dhulia Memorial Lecture in this historical auditorium of Forest Research Institute, Dehradun. I have always believed that memorial lectures, if they are to be truly meaningful, must do more than mere recount the achievements of those in whose honor they are instituted. They must seek, however imperfectly, to engage with the moral universe that shaped them, the values they lived by, and the quiet yet enduring influences they leave behind. For it is that deeper understanding that we discover not only the contours of their legacy, but also the measures of our own responsibilities. Today, as we gather to remember Justice Keshav Chandra Dhulia, we are confronted with a unique legacy, one that is at once incomplete in its judicial expression, yet profoundly complete in its human impact. Justice Dhulia's life reminds us that the measure of a jurist is not always confined to volumes of reported judgments. Sometimes, the truest legacy of life lies beyond the courtroom, in the values one nurtures, the integrity one lives by, and the lives one shapes. Born in November 1929 into a household steeped in public spirit and intellectual courage, Justice Keshav Chandra Dhulia inherited a rich legacy. His father, Shri Bhairavadat Dhulia, was among the foremost freedom fighters of the Garhwal region, who was even jailed for many years during the freedom struggle. He was among the founding editors of Karambhumi Saptahik, which was known for its independent and courageous editorials during colonial India. It was a time when speaking truth to power was not merely an act of courage, but an act of defiance. From such a lineage, Justice Dhulia imbibed a deep commitment to public service, intellectual honesty, and fearless engagement with the world. His academic journey took him to Allahabad, which was then a crucible of legal and intellectual thought in India. From there, he began his legal practice at the local court at Lansdowne before moving to Allahabad High Court, where his abilities, diligence, and integrity earned him huge recognition. He rose to become the chief standing counsel for the state, and eventually he ascended to the bench in 1984. And yet, even with only a brief tenure of just 8 months on the bench, his judicial career bore unmistakable promise. In that short span, he was part of benches that delivered noteworthy judgments reflecting both clarity of thought and depth of conviction. He was also widely regarded for his diligence and efficiency, particularly in ensuring the early disposal of cases. We often measure judicial greatness by the longevity of service or the volume of jurisprudence. But perhaps there is another, quieter measure. It is something that resides in the unseen, in the influence that extends beyond written words. In that sense, the life of Justice Dhulia was not curtailed, it was continued in more than one ways. It is reflected in the extraordinary family he raised with his equally accomplished and inspiring wife, respected Mrs. Sumitra Dhulia, a distinguished professor of Sanskrit. In her continued commitment to public service, she serves as the chairperson of the Karam Bhumi Foundation, which has not only organized this memorial lecture, but also contributed meaningfully to initiatives aimed at the welfare and development of Uttarakhand. Together, they built not just a household, but a tradition of excellence. The three sons stand as living testaments to that legacy. My brother Justice Sudhanshu Dhulia adorned the highest court of the land. Mr. Himanshu Dhulia served the nation with distinction in the Indian Navy, and Mr. Tigmanshu Dhulia has carved out a unique space in Indian cinema as an actor and a director of remarkable depth. Each of them, in their own domain, has achieved distinction, but more importantly, each reflects a certain intellectual independence, a certain seriousness of purpose, a certain commitment to excellence that does not arise by accident. It arises from upbringing, it arises from the values lived, not merely taught. It is said that truth and true worth of life lies not in what it accumulates, but in what it inspires. Justice K.C. Dhulia's life inspired us to look beyond the visible markers of success and to recognize the deeper current of influence, of character, of integrity, and of strength. And therefore, we have a living legacy of character, discipline, and public service. It is from this deeply human and profoundly instructive legacy that we must now, ladies and gentlemen, turn to the theme that brings us together this afternoon: legal awareness and access to justice. In fact, when I discussed with Justice Sudhanshu Dhulia the theme on which I should share my views, eventually I realized that the amount of contribution sacrifices made by late Justice K.C. Dhulia, and that he was known to be a judge for the common masses, I deemed appropriate that I should speak on a subject which must be close to his heart also. And that's why I chose legal awareness and access to justice, the theme. I will try to share my views very briefly. When the Constitution of India was being debated, there was a clear and conscious recognition that the mere articulation of rights would not suffice. Among the voices that raised this concern with clarity was Ms. Hansa Mehta, one of the members of the Constituent Assembly. There were 15 women members. Nowadays, we respectfully address them as the mother of the Indian Constitution. She cautioned that rights, unless translated into the lived realities of citizens, risk remaining formal declarations present in text but absent in experience. That insight, though expressed in the formative years of our republic, continues to define the central tension of our constitutional journey: the distance between the law promises and what the citizen experiences. The Constitution does not conceive of justice as an abstraction. It envisions justice as a lived condition, something that must be experienced by every citizen, irrespective of social or economic standing. Article 39A gives institutional shape to this vision by mandating that the state shall ensure that the operation of the legal system promotes justice based on equal opportunity, and that free legal aid is provided so that no citizen is denied access to justice due to economic or other disabilities. This provision has been consistently interpreted by constitutional courts as imposing a positive obligation on the state to remove barriers, economic, procedural, and informational, that stand between the individual and the justice. This is not a matter of policy preference. It is a constitutional command. And yet, more than 7 decades after independence, the question that confronts us is not whether institutions exist, but whether they function in a manner that makes justice meaningfully accessible. India today has one of the largest judicial systems in the world, with over 25,000 judges, judicial officers across the district judiciary, high courts, and of course the Supreme Court, and a caseload that exceeds almost 5 crore pending across all levels. These numbers are not merely statistics. They reflect the scale of demand placed upon the justice delivery system and the urgency of making that system more responsive, efficient, and accessible. Ladies and gentlemen, I may just out of context clarify that sometimes there is a misnomer and a misconception that there are arrears of 5 crore. That is not true. A case which is filed today is Sunday, tomorrow Monday, if a case will be filed tomorrow, in the evening by 5 p.m., the national data grid system will add that case in total pendency. But do you think that a case which is filed on that very day will become an arrear? I think all of you will agree that there is a difference between pendency and arrears. Arrears are only those cases which are ripe for final disposal, and if at all on account of long pendency, if their turn does not come and the courts are compelled to give certain adjournments and those matters are eventually taken up as per their queue, that may be counted as arrears. And if applying this yardstick, which I have been strongly advocating after taking over as Chief Justice of India, I don't agree and I don't believe that the arrears are 5 crore. Only the arrears are only a substantial part thereof, but most of the cases are only pending cases where the common law procedure, the statutory procedure that Indian legal system commands are required to be followed, and if you follow those principles which are in conformity with principles of natural justice, those cases will take their reasonable time for disposal. But significant institutional efforts have been made to bridge the gap even between the cases which are pending or which have been termed as arrears. The National Legal Service Authority and the network of state legal service authorities have over the years expanded the reach of legal aid through legal aid clinics, paralegal volunteers, and targeted outreach programs. The Lok Adalat systems, which has disposed of crores of cases, has provided an alternative, less adversarial form for dispute resolution particularly for economically weaker sections. More recently, last year when I was chairperson of the National Legal Service Authority, I gave a slogan, mediation for nation. And it was not a mere slogan. I am using the word consciously. Initially, I thought that let it be a kind of a statement that people will try to react and follow. But believe me, that ultimately mediation became one of the commitment in the Indian judicial system. At all levels it was followed, and today I can proudly say that the expression mediation has entered every house where there is a dispute worth resolution. Parallelly, the judiciary has undertaken an ambitious process of technological transformation. The e-court mission mode project, now its advanced phases, has led to the digitization of case records, introduction of e-filing, and the availability of virtual hearings. Yesterday only National Conference of E-Committee has started, and in the morning yesterday while inaugurating, I have launched various e-technology based apps and modules and softwares through which now even service of notices in the matters which are being filed will be done without using the manual procedure which was the conventional practice, particularly at the taluka level courts and in the district courts. And we are quite confident that the apps and the software or the mechanism which we have introduced yesterday is going to help in a great way in expediting the procedural hearings. Today lakhs of cases are listed and heard through digital platforms, and judicial data is increasingly accessible through the National Judicial Data Grid, which provides real-time information on case pendency and disposal. These initiatives represent a significant shift towards transparency and efficiency. The executive, in collaboration with legal service institutions, has also launched initiatives such as Tele Law Program, which leverages common service centers to provide legal advice to citizens in the remote areas through video conferencing. I am told that Tele Law has facilitated millions of consultations, particularly benefiting those who would otherwise have no practical access to legal counsel. Such initiatives demonstrate the potential of combining institutional reach with technological innovation. And yet, despite these efforts, a fundamental challenge persists. Access to justice cannot be measured merely by the existence of forms or the availability of schemes. It must be measured by the ability of individuals to meaningfully engage with the system. For a significant section of our population, the legal system continues to remain distant, not only in physical terms, but in conceptual and psychological terms. The language of the law often appears inaccessible, procedural, and all the procedural requirements seem complex and opaque, and the costs, both financial and emotional, are prohibitive. There is an anecdote often recounted in discussions on this subject. A villager, when asked why he had not approached the court for a grievance, might have responded, the court may be open for all, but it is not meant for people like me. That is the mindset created by the negativity in the system, that why a common man, a poor villager, a person marginalized, why do they feel that going to the court is not an easy task, or that it may not be meant for them, or that only a few elite group in the system can have and can afford the judicial system. That statement captures a fundamental truth. Access is not merely about entry, it is about inclusion. It is about whether the citizen feels that the system is designed for them, whether they can navigate it without fear, and whether they can understand its processes without dependence. Justice, therefore, must not only exist, it must be approachable. It must inspire confidence. It must be intelligible to those it seeks to serve. The challenge before us is not merely to expand institutions, but to humanize them, to ensure that the constitutional promise of justice moves from the realm of text into that of lived experience. So, what are the initiatives that need to be taken? I believe that legal awareness is the first pillar of access. If access to justice is the destination, legal awareness is not merely the path, it is the very condition that makes the journey possible. A right that is unknown in substance is a right denied. A remedy that is not understood in fact is no remedy at all. Legal awareness must therefore be recognized not as an adjunct to the justice system, but as its first and most indispensable pillar. In this context, the insights of Mrs. Renuka Ray during the Constituent Assembly debates acquire enduring significance. Another woman member of the Constituent Assembly. She cautioned that even the most progressive legal reforms would remain inert unless accompanied by a corresponding transformation in social consciousness. Law does not operate in abstraction. It draws its vitality from the awareness, acceptance, and assertion of those whom it seeks to serve. This understanding compels a shift in our approach. Legal awareness cannot be episodic, symbolic, or confined to periodical campaigns. It must be systemic, sustained, and deeply embedded in the fabric of everyday life. Awareness is not created through dissemination alone, it is cultivated through engagement, through dialogue, participation, and trust. It must begin early, within the education system, where the teaching of law is not reduced to technicalities, but introduces young citizens to the language of duties, constitutional values, and rights. I am happy that very good amount of students are sitting here. I hope that they will get sensitized on this issue in their law universities. The legal awareness must be extended into workplaces where individuals are made conscious of their entitlements and protections in conditions often marked by asymmetry of power. And it must be rooted in communities where legal issues are not distant abstraction but lived realities requiring collective understanding and response. The consequences of this deficit in legal awareness are neither abstract nor remote. Consider the case of a young woman who believes that she has no right to refuse marriage arranged against her will. The law unequivocally does not stem from the absence of legal protection, but from the absence of legal awareness. In that moment, the distance between law and justice becomes starkly visible. Equally, there are countless instances where individuals suffer in silence, not because remedies do not exist, but because the very idea of seeking a remedy does not occur to them. Wage exploitation goes unchallenged. Domestic violence remains unreported. Entitlement under welfare schemes remain unclaimed. These are not failures of legislation. They are failures of communication, outreach, and trust building. In an age increasingly defined by digital connectivity, legal awareness must also adapt to new mediums of engagement. Technology offers unprecedented opportunities to disseminate information, but it also risks deepening exclusion for those who lack digital access or literary. That's why there is a lot of hue and cry on digital discrimination. The challenge, therefore, is not merely to digitize legal awareness, but to democratize it, to ensure that innovation enhances inclusion rather than reinforce existing divides. This responsibility places a corresponding obligation on institutions, legal service authorities, civil society, education institutions, and of course the bar must work in connect to transform awareness from a passive flow of information into an active process of empowerment. The measure of success cannot be the number of awareness programs conducted, but the extent to which individuals are able to recognize, assert, and enforce their rights in real world context. The second aspect is reimagining access in the digital age. Now, if legal awareness is the first pillar of access to justice, technology represents the architecture through which the awareness can be translated into meaningful action. Awareness illuminates rights, but it is access that enables their enforcement. The digital age offers us an unprecedented opportunity to bring those two dimensions into alignment, to ensure that knowledge of rights is matched by the ability to act upon them. We are living in an era defined by technological transformation. The digital revolution has fundamentally altered the way we communicate, transact, and engage with institutions. In India, this transformation has been particularly striking. The rapid expansion of digital infrastructure has created new pathways for inclusion, compressing distances that once appeared insurmountable. In this context of justice delivery, this transformation is not merely incremental, it is potentially transformative. Technology can reduce geographical barriers, lower transaction costs, and provide information in real time. It can simplify the procedures, minimize dependency on intermediaries, and make the law more intelligible to those who need it most. Properly harnessed, it can convert legal awareness into actionable empowerment. One may imagine some citizens in a remote village equipped with nothing more than a basic mobile device, being able to access clear and reliable legal information in their own language, to understand the remedies available to them, and to connect seamlessly with a legal aid provider without the burden of travel, delay, or expense. One may imagine digital platforms that demystify legal procedures, translating complexity into clarity and formality into accessibility. These are no longer distant aspirations, they are possibilities within our own immediate grasp. And I can again, out of context, happily announce that today only in the conference, Nalsa Regional Conference in Dehradun, the Uttarakhand Legal Service Authority has launched some apps, and that includes the mobile apps upon which you can have complete access, you can have legal assistance, you can have legal opinion, you can have legal aid counsel, and you can also find out the details of your case, pending case, or the opinion whether you should go to the court or not, including the pre-litigation platforms like mediation, etc. Now, at the same time, we must remain attentive to emerging risks that risks are brought by technology. As justice system move into the digital spaces, concerns of data privacy acquire increasingly significance. Access to justice cannot be at the cost of fairness, autonomy, or accountability. The design of digital legal systems must therefore be guided not only by efficiency but by constitutional values. Ultimately, even in an age of rapid technological advancement, we must remember that justice is not a purely transactional outcome. It is a deeply human experience. It is shaped by dignity, empathy, and the assurance that one has been heard. Technology can facilitate access, but it cannot substitute the human core of justice. The task before us, therefore, is not to choose between technology and tradition, but to harmonize them, to build a justice system where digital innovation amplifies human sensitivity and where access is not merely expanded but equalized. Only then can the promise of legal awareness, which begins as knowledge, culminate in justice that is truly experienced. The third thing I feel is towards an ecosystem of justice. If legal awareness is the foundation, and technology is the enabler, then what ultimately sustains access to justice is an ecosystem, one that is collaborative, responsive, and anchored in shared constitutional purpose. Access to justice cannot be realized through isolated interventions or fragmented initiatives. It requires a coordinated and sustained effort across institutions, each discharging its role with a sense of collective responsibility. First, the judiciary. The judiciary, as the sentinel of constitutional rights, must continue to innovate not only in adjudication but in the design of processes that are accessible, intelligible, and humane. Procedural reforms, the use of technology, and a continued emphasis on legal services must converge to ensure that justice is not delayed, diluted, or denied at the threshold. The executive, role of the executive, for its part, bears the responsibility of creating the enabling conditions within which access can be meaningfully realized. This includes investment in digital and physical infrastructure, strengthening legal aid institutions, and ensuring that policies are designed with an acute sensitivity to ground realities. Access to justice is not merely a judicial concern, it is a governance imperative. The third player, stakeholder, is the Bar Association, the members of the Bar. The Bar occupies a position of unique significance in the ecosystem. It is often the first point of contact between the citizen and the justice system. The commitment of the legal profession to ethical practice, pro bono service, and client sensitivity is therefore indispensable. The law at its most effective is not merely argued, it is guided, explained, and made accessible through those who practice it. Equally, academia, fortunately today sitting here, academic institutions, particularly the law universities, must assume a more active role in shaping the future of access to justice. Legal education cannot remain confined to doctrine and theories. It must cultivate a sense of social responsibility, encouraging students to engage with legal aid, community outreach, and the lived realities of those who remain outside the formal structures of justice. In doing so, it ensures that the next generation of lawyers is not only professionally competent but socially conscious. The other stakeholder is civil society organizations and community-based networks involved and those who complete this ecosystem. They operate at the interface between institutions and individuals, often reaching those who are otherwise invisible to formal systems. Their work in building awareness, facilitating access, and fostering trust is indispensable. In many ways, they give tangible form to the idea that justice must travel to the citizen rather than waiting for the citizen to find out it. What emerges, therefore, is not merely a framework of justice, but a philosophy that places the citizen at its center, one that is not confined to institutional response, but is animated by facilitation and access. It is an approach where awareness becomes the first step towards empowerment, accessing the means of participation and asserting the pathway to meaningful enforcement. In many ways, this vision, ladies and gentlemen, resonates with the life and work of Justice Keshav Chandra Dhulia, whose own judicial approach reflected a deep and abiding commitment to making justice real, accessible, and responsive to those it seeks to serve. As we reflect on the life and legacy of Justice Keshav Chandra Dhulia, we are reminded that the true measure of a life lies in its duration, does not lie in its duration, but in the depth of its contribution. Some lives and some lives leave behind memories, others leave behind direction. His belongs firmly to the later. His journey stands as a silent but enduring testament to the power of integrity in public life. It reminds us that institutions are ultimately shaped by the individuals who inhabited them, and that values, one lived with conviction, acquire a permanence that outlasts time. In an age often defined by speed and change, such examples anchor us to what must remain constant. But remembrance by itself is not enough. The most meaningful tribute we can offer is not in words, but in the choices we make and the systems we build. This memorial lecture, therefore, is not merely an act of reflection, it is a call to action. It calls upon us to reimagine access to justice, not as an abstract ideal, but as a lived and measurable reality. It calls upon us to ensure that the law is not distant, but within reach, not complex, but comprehensible, not intimidating, but enabling. It calls upon us to build a system in which legal awareness empowers, technology includes, and institutions respond with sensitivity and purpose. If we can move, even incrementally, towards a framework where every citizen aware of their rights, confident in asserting them, and assured of a fair, timely, and humane response, we would not only be fulfilling a constitutional mandate, we would be strengthening the very foundation of our democracy. And in doing so, we would carry forward a legacy in the truest sense, not by preserving it in memory alone, but by giving it contemporary meaning. For the enduring tribute to a life of public service lies in ensuring that its values continue to find expression in the lived experience of those whom the law is meant to serve. Thank you very much, ladies and gentlemen, for your patience hearing. Thank you very much for giving this opportunity to me to be here with you and share my views. Thank you very much.
Thank you, sir. How true is that to say call for action? Your address has not only enlightened us, but also given us a deeper perspective on justice and especially access to justice. Your insight will continue to guide and motivate us and move forward both individually and collectively as a society. Thank you so much, sir. May I now request Hon'ble Justice Sudhanshu Dhulia to present a memento to our Chief Guest, Chief Justice of India, Justice Surya Kant. It's a token of our affection, sir. The memento presented is an idol of Golu Devta, known as God of Justice, an incarnation of Lord Shiva, and is a highly revered deity in the hills of Uttarakhand. May I request Justice Dhulia to present one to Honorable Justice Satish Chandra Sharma too. Thank you, sir. May I request Mrs. Sumitra Dhulia, Chairperson, Karambhumi Foundation, to present a memento on behalf of the Karambhumi Foundation to our Chief Guest, Chief Justice of India, Justice Surya Kant. It's a pen-ink drawing of Mahasu Devta temple etched on a wood, which was originally sketched by Sri Ratin Mitra, India's leading visual essayist from Kolkata. He is also known for the longest mural in India and has a deep connection with Dehradun, as he was head of the arts at the prestigious Doon School for over 2 decades. May I now request Mr. Tigmanshu Dhulia to present a shawl again woven by the women of Almora It's a special gift for you, sir, from the hills. May I now request the Vice Chancellor UPES to present a memento to our Chief Guest, Chief Justice of India, Justice Surya Kant. May I now request our Actor Director, Mr. Hon'ble Dhulia, to please take up the stage to present the vote of thanks.
तो ये अंतिम घड़ी आ गई और सबसे ज़रूरी चीज़ होती है, इसको बोलते हैं वोट ऑफ थैंक्स। इसमें औपचारिकता के अलावा और कुछ नहीं होता। तो कहीं कोई छूट ना जाए, कोई छूट जाएगा तो मैं माफ़ी चाहूँगा। सबसे पहले आवर टोकन ऑफ अप्रिसिएशन, किताबें, डॉक्टर माधुरी बर्थवाल, ऑनरेबल चीफ जस्टिस साहब, सर आपको, प्रोफेसर आशुतोष त्रिपाठी जी ऑफ यूपीएस for his cooperation, Professor Namneet Rajoria of UPES for his constant help, Shri Anurag Nautiyal for designing work. I request Ankur Nautiyal ji to collect on his behalf, as he could not come from Lucknow. Shailendra Sharma ji for being a pillar of strength, Shailendra Sharma ji. And finally, the master of ceremony, the madam of ceremony, Wing Commander Anupama Joshi, my sister. मैं शुक्रिया अदा करना चाहूँगा यूपीएस के ऑनरेबल वाइस चांसलर साहब सुनील राय साहब, आपका बहुत बहुत शुक्रिया। और एफआरआई इस हिस्टोरिकल वेन्यू एसएस रावत जी का मैं बहुत बहुत शुक्रिया अदा करना चाहूँगा। यहाँ पे मैंने वैसे बहुत शूटिंग भी की है एफआरआई में, बहुत खूबसूरत जगह है। एंड आई थैंक ऑल द स्टूडेंट्स एंड फैकल्टी मेंबर्स ऑफ दिस फॉर द एंथुजियाज्म एंड फॉर attending the lecture in such large numbers. Thank you all, boys and girls. मुझे आपको काफ़ी ज्ञानवर्धक बातें सुनने में आई। आई एम श्योर आपको बहुत आसानी होगी अपने लॉ की पढ़ाई में। मैं आशुतोष ध्यानी जी का शुक्रिया अदा करूंगा फॉर लाइव रिकॉर्डिंग उन्होंने की इस इवेंट की। और ये प्रोग्राम डिस्ट्रिक्ट जज देहरादून के कौशिवा साहब के बिना हो नहीं सकता था। मेरा सिंसियर थैंक्स आपको सर। एंड आई थैंक ऑल द ऑनरेबल जजेस, द चीफ जस्टिस ऑफ उत्तराखंड for gracing the occasion. Thank you very, very much. I thank all the lawyers of Uttarakhand and for the presence this evening, this afternoon, sir. My sincere thanks to all the eminent citizens of Dehradun who are here and family and friends of Uttarakhand Foundation. And my most sincere thanks and gratitude to the Honorable Justice Surya Kant ji for his enlightening lecture. Sir, we shall be ever grateful to you, sir. और मैं माफ़ी चाहूँगा अगर मैंने किसी का नाम छोड़ दिया हो, तो बाहर आके आप मुझसे अपनी नाराज़गी व्यक्त कर सकते हैं. बहुत बहुत शुक्रिया. Thank you.
Thank you, Timanshu. It's time for the group photographs. So without wasting time, I'll request the guests to stay on the stage, please. And may I request the judges and the lawyers of Uttarakhand to please walk up on the stage for a group photograph. Post that, I'll request the friends and families of Karambhumi Foundation to be ready. You can start moving on your seats. You वहीं रहेंगे इनको. I think they should stand. All the honorable judges of Uttarakhand and members of the law fraternity of Uttarakhand, thank you so much. We can see you've been here in a large number. May I request you to please form we have only one lady. May we request you to give some space to her? Yes. If people are not fitting in the frame, we can do it in 2 sessions. Gentlemen, if the photographer, please tell us if they are not fitting in the frame, we can do it in 2 pieces. Yeah, so could you just tell some people to move on the side and take a picture, and then they can step forward. I'll request the photographer to take the lead on this, please. Thank you. Can we have the next lot of the law fraternity of Uttarakhand? I repeat, I request the photographer, आप lead लीजिए इसमें, आप बताइए. हाँ जी. Okay. Thank you, gentlemen. May I now request the family and friends of Karambhumi Foundation to please come up. The friends and the family of Karambhumi Foundation, please walk up. Lokesh ji, Ashish, please come. May I request the legal fraternity to exit the stage, please? I'm sorry about that, but because of paucity of time, I'll have to call out. May I request the law fraternity to please exit the stage. I'm sorry about that, but can you give the space for the family and the friends of Karambhumi Foundation to... Can we request the friends and family to please gather around the guest, and the rest of you, may I request you to please exit the stage. Thank you so much. The family, could you move a little faster? May I request all the students available here to start walking up towards the stage, all the students, whichever university that you are from. Thank you so much, the friends and family, whoever has been here. Thank you, the friends and family of Karambhumi. Can we make space for the students now? All the students of the law faculty of whichever university they are. I can see the students from the Doon School. Please walk up. Thank you. Thank you, everybody. May I request you to please exit the stage and make way for the students. I'll request you to take your seat back and give some space to the students, please. Students, could you start walking up on the stage, please? Students, may I request you to start walking up on the stage? We have a paucity of time. And the family, my dear family, could you exit the stage? Last but not the least, the students, please make... It's important for the students to be here. And once the photo is clicked, students, I request you to stay back on the podium till the time Chief Justice exits the hall. And rest of the people standing outside, may I request you to please sit on your seats and not crowd around the alley. Students, please come up on the stage. Students, could you turn your face towards the camera? I think... You guys are looking a little distinct. Make way for yourself, boys. Can we have our director to direct this mob, I guess? Is Mr. B.P. Nautiyal here? Your wife is waiting for you at the gate. Mr. B.P. Nautiyal. Yeah, students, you can look and smile at the camera. Turn towards the camera. You can put your hands up and say cheers. Thank you so much. Thank you all for your patience. Thank you all once and for all. Ladies and gentlemen, thank you so much for being such a patient audience. I know everybody would like to spend much more time, but thank you. Wish you all a happy weekend, and we'll see you again with the next edition. Jai Hind.